The Whistleblower Protection Enhancement Act, protecting federal workers from whistleblower retaliation. You are bringing a claim essentially that the agency, the federal agency, has committed a prohibited personnel practice. You've disclosed fraud, waste, or abuse, a gross waste of funds, an abuse of authority, substantial and specific danger to public health and safety. It can also mean you've participated in the exercise of any grievance, appeal, or complaint that's allowed by law. So if you've engaged in Office of Special Counsel activity, if you've engaged the OIG, the Office of Inspector General, or you've participated in union-related activity, you've participated in contested proceedings and you're retaliated against, it would be a prohibited personnel practice. There are two ways to get to the Merit Systems Protection Board so that you can litigate your whistleblower claim. Number one would be an individual right of action. This is basically an indirect route. If there is a personnel action that is not otherwise appealable to the MSPB, the MSPB does not have jurisdiction over the type of personnel action normally. For example, the MSPB has jurisdiction over wrongful removals, demotions, suspensions that are 15 days or more. If you have a personnel action that has been taken against you that does not fall under the board's otherwise appealable adverse action jurisdiction, then you must contact the Office of Special Counsel first or exhaust your administrative remedies first and give the administrative process a chance to issue corrective action. After you've exhausted your administrative actions, you will receive a closure letter. The final closure letter will give you your rights and your deadlines to file with the Merit Systems Protection Board. The second route to the MSPB is directly, where you can allege that the wrongful action was taken because of retaliation, and you would allege this as an affirmative defense. In other words, you would add it on to your appeal. So a wrongful removal, for example, is something that the MSPB already has jurisdiction over. So you would simply add on that in addition to the wrongful removal for the various reasons that you allege, such as the agency has not proven the charges or the conduct, the punishment does not fit, there should be mitigation, etc., you can allege affirmative defenses where you add on whistleblower retaliation or retaliation for engaging in a grievance. That's how you get into the MSPB to litigate your claims. The first thing that you must show for a whistleblower complaint is that the disclosure or the activity was a contributing factor in the agency's decision to take or to threaten to take a personnel action. So contributing factor means any factor which alone or in connection with other factors tends to affect in any way the outcome of the decision. There are two ways to establish whether or not there was a contributing factor. Number one is through the use of the knowledge timing test, and number two is through the use of any other evidence that demonstrates that your protected activity was a contributing factor. The knowledge timing test simply says that the decision maker knew of the protected activity and the personnel action that was taken, the adverse action, was taken within a reasonable time of that protected activity, or it was initiated within a reasonable time. In other words, the timing has to be close enough so that some kind of inference can be drawn. After you've met your initial threshold, the agency has to show by clear and convincing evidence that it would have taken the same personnel action in the absence of whistleblowing. It's a higher standard for the agency to have to meet. To determine whether an agency has shown by clear and convincing evidence that it would have taken the same personnel action in the absence of whistleblowing, the MSPB considers three factors. Number one, whether the agency had legitimate reasons for the personnel action. Two, The existence of any motive to retaliate on the part of the agency officials who were involved in the decision to take the personnel action. So, any motive. Number three, any evidence that the agency takes similar personnel actions against employees who are not whistleblowers, but who are otherwise similarly situated. Now, there's a lot that goes into a whistleblower complaint. This gives you the overview and how to actually get to the MSPB, the burdens of proof,